the last week of February, at the International Criminal Court at The Hague, we heard the arguments from the defense on behalf of the former President Rodrigo Roa Duterte for the very first time. Certainly, lead defense counsel Nicholas Kaufman came out swinging. But did he hit his targets? And were they the right targets in the first place? Hi, I'm John Nery, and you are in the Public Square. Two distinguished specialists in international law will critique Kaufman's performance at the confirmation of charges hearing today. Attorney Ruben Carranza is the senior expert for programs at the International Center for Transitional Justice and joins us from New York. Attorney Romel Regalado Bagares is deputy chair of the Department of Maritime Law and International Law at the Philippine Judicial Academy. He joins us from Quezon City. Welcome back, Attorney Ruben and Attorney Romel, and thank you for joining us yet again in the Public Square.
Well, happy to be here.
Thank you for having me.
Let me start with expectations. Attorney Ruben, based on the reputation of the British-Israeli lawyer Nicholas Kaufman, what were you expecting him to do?
I was expecting him to do what he did, which is to mix arguments with political speech, which unfortunately he also has done in some of the other cases that he has participated in. He didn't disappoint. Certainly he didn't disappoint Rodrigo Duterte followers because I doubt that many of them understand the stage of the case as we saw last week, and many more, not just the Duterte followers, but many more Filipinos probably understood the political speeches far more than the technical issues and standard of evidence that was necessary, that was applied in that stage of the proceeding. So Kaufman didn't disappoint, and even after the actual hearings, his continued political speech making certainly was something consistent with his practice before the ICC.
So argument mixed with political speech. Attorney Romel, based on ICC practice, what were your expectations from Kaufman?
Well, I think he drew from the usual playbook really for cases like this as for indirect co-perpetration. So he tried to attack causation. He tried to attack the notion of control. And of course, as Ruben said, the political was very much at play here. But for me, I think he went from fairly bad to really worse. From his initial presentation towards his presentation towards the end, because maybe he did not realize that Joel Butuyan and Gilbert Andres were actually the counsel for the Supreme Court case that he was citing. So I think he was banking on the judge's unfamiliarity with some of the evidence of the prosecution. But I think that really was a trap for him when he cited that case, which actually goes into the question of admissibility. Remember, his political speech says that there's no jurisdiction, this is a sovereign state. But then the Rome Statute talks about complementarity, and that case goes into complementarity. Imagine 9 years of litigation. It's been pending for 9 years and no resolution there. It means that there's no hope for remedy even from at the highest levels of the court in the Philippines, right? And the memorandum was precisely what was attacked there. It's not just the neutralization, but the evidentiary requirements actually of the memorandum with respect to a death arising from a police operation. So that was really my judgment. That was fairly bad to worse for me.
Okay, spoiler alert, okay, for Attorney Romel, bad to worse. Can I ask Attorney Ruben, so you were not disappointed based on your expectations, but how would you assess his performance? Was it good, was it bad, or can you measure it?
There were two legal arguments that he raised, which were to me both surprising and one of them at least was alarming, disturbing. The first one was on the definition of crimes against humanity. He attacked the prosecution by claiming that the drug war wasn't an attack that fell within the definition of crimes against humanity. Basically, his argument was that the persons killed in the drug war were a very specific subset of human beings, and therefore not the humanity, not the large, in a way, amorphous mass of humans that he claimed would be the people contemplated in the definition of an attack against civilians. And that was disappointing in the end because even from the point of view of the defense, it doesn't really accomplish much for his client. It only raises a question around whether the drug war was even more deliberate than Duterte and the co-perpetrators that have been named meant it to be. And therefore, the element of targeting was in fact more emphasized rather than de-emphasized. The other argument he made that was to me more disturbing, and I think this is something that Filipinos and commentators in the Philippines should really be more aware about, was the insistence by Kaufman at different points in the 4 days to name names, name witnesses, have them identified, whether they were insider witnesses or perhaps victims. The watching public never got to know exactly who he identified, whether by nickname, by description, or by some other means, because they were removed from the live stream. There was a 30-minute delay, so the ICC could remove those references. But he kept repeating that even after the admonition by the presiding judge. Judge Motok specifically told him to stop doing what he was doing. The prosecution specifically moved to remove the references because not only because it wasn't allowed, but because it was going to endanger the persons that he was describing. And that is very disturbing because this is not unprecedented. In the case involving the former president and now also the current president of Kenya, Uhuru Kenyatta and William Ruto. Uhuru Kenyatta was at one point a candidate for Kenya president. He was later elected. William Ruto was his vice president and is now the president of Kenya. They were charged with crimes against humanity involving political violence in Kenya. To cut a long story short about the Kenya case, the prosecutor at that time had to withdraw the charges because witnesses were being killed. Even a lawyer was found dead. All in all, about 13 people connected to that case were either killed or disappeared in Kenya. What is more disturbing is that the law office of Kenyatta is the same law office that Kaufman's co-counsel right now in the Duterte case works for, Dov Jacobs. You could see him in the live stream. He was seated to the left of Kaufman. Dov Jacobs works for this law firm in London called 9 Bedford Row. And 9 Bedford Row's lead counsel was the lead counsel of Uhuru Kenyatta in the Kenya case. So it's disturbing because it names names, it endangers witnesses, it endangers victims' families.
Attorney Ruben, this second argument, which you describe as disturbing, was it also like the first argument in that it did not advance Duterte, the defense of Duterte?
Yes, clearly, because he was playing to not just to the gallery in the courtroom, but to Duterte followers. Judge Motok already pointed out to him the redactions are redactions from the public view. They are not redactions for lawyers because lawyers can obviously access those names.
Attorney Romel, what were the other legal arguments that Kaufman used, which you found wanting?
Okay. Now, I want to address what Ruben said now, but I think Kaufman was trying to attack the second alternative mode of liability, because it's not highlighted, but there are actually three modes of liability tackled in this case. It's in co-perpetration, there's the ordering and the inducing, and finally there's aiding and abetting. So Kaufman was saying there's no insider witness testimony to say that they actually heard Duterte order any killing when he was mayor. But if you look at the documents containing charges, all the three counts there list these two other criminal modes of criminal liability, alternative modes of criminal liability. But we know, at least in the Philippines, there have been testimony or affidavits before of insiders in the inner circle of Duterte are said to have become witnesses for the ICC. But these are documentary evidence as of yet, because this is pre-trial. This is the confirmation charges. No, generally would be sitting, as we saw, right? And so that was his line of attack there. That if that ordering or inducing would not have any water, but as we know, there's actually that, and perhaps he was. The intention there really is to stir up the Duterte camp. But the second line of argument, which I also found interesting, is that he used the sine qua non. This is very academic, on causation, sine qua non, but for argument. But it's not generally used in international criminal law, especially where you have multiple actors. You can look at the practice of the International Court of Justice, where it has been extensively used. Where what was a trial was the responsibility of states. Bosnia, involving genocide, but it was the state being held responsible for what happened, right? Or the Diallo case, more recently, Democratic Republic of Congo, if memory serves. So he's actually trying to insert now into the record, perhaps for trial at some point, to use this theory of sine qua non to say, well, you have control, but you cannot really prove that. There's a direct line from Duterte to what happened. But the thing is that it's a linear model of causation. It sounds scientific, but for control, for indirect co-perpetration, you cannot do that because you have multiple actors. Precisely, the theory is control, right? You have the state machinery, you have co-perpetration and co-perpetrators, and Duterte as a indirect co-perpetrator. So I think that he wants to use that theory of causation when he goes to trial. He expects that's going to be a trial, but he wants to use that as a mode of causation to dismember the link between Duterte as the lead person who designed the criminal design, right? The plan to kill drug suspects, and what happened after the policy was implemented by the state machinery involving key people from his inner circle. So that was interesting for me, but I thought that, well, you don't use that in a case like this, like indirect co-perpetrator. But that is interesting from the academic point of view. Maybe it's difficult to understand that for ordinary people, but it's an important argument, I think, for Kaufman.
To go back to the first, to your first response, Attorney Romel, the surprising arguments actually, if I understand you correctly, advance a defense objective, chipping away at a level of liability. It sounds to me like that was a good thing for Kaufman. I mean, is that where it becomes worse or bad? I mean, I'm trying to make sense of your assessment from going from bad to worse. This sounds like a good thing for the defense.
Yeah, but as I said, he actually failed there because by doing what Ruben said he did, he was actually signaling that it was a desperate move because he knew that there really are insider witnesses who could pinpoint, who could say that Duterte ordered this in my presence.
Okay.
And that's why he had to read all those names. Well, of course, aside from that, there are other cases that I know not listed in the representative cases tackled in the proceedings thus far, but they are key witnesses, survivor witnesses for that matter, that will be presented at trial, but it's not listed in the, or that whose names the witnesses have been redacted from public view, precisely because they have still families in the Philippines. By doing what he did, he signaled this desperation really there. And he had to attack. He had to try to make that public despite the agreement earlier. I think that's really unethical. But I don't know if someone's been cited for unethical conduct on that score in the ICC with respect to that particular issue where there's already repeated admonition from the judges not to do that, but still the counsel kept on doing it.
Before we turn to other arguments that he raised, I want to address the ghost of Jerry Spence. I'd like to ask Attorney Ruben first and Attorney Romel. Of course, we're talking about two very different cases, two different judicial systems and so on. But in 1990, Imelda Marcos was facing racketeering charges in New York. And her very folksy lawyer, Jerry Spence, was able to convince the jury to acquit her, essentially putting the blame on the dead President Ferdinand Marcos. I'm just worried that we might be underestimating Kaufman. He's been practicing at the ICC and he's won cases. Maybe he's doing something that in the end will remind us of the ghost of Jerry Spence. Attorney Ruben first.
Well, there's no jury in the
Yes.
International Criminal Court, and that makes a very significant difference, if not a decisive difference, because it's the technical argument that might really sway the judges one way or the other. And at this stage, it's really just substantial grounds for proceeding to trial that is at stake, not proof beyond reasonable doubt. So at this stage, I don't think that will work to prevent the case from going to trial. The political speech, the naming of witnesses, the antics of Nick Kaufman. But to your point about Nick Kaufman having experience, there was a case, the case against Jean-Pierre Bemba, former vice president of the Democratic Republic of Congo, for war crimes against humanity. And at the trial, pre-trial and trial, the prosecution relied on an insider witness, a couple of them, to prove that Jean-Pierre Bemba knew that there were crimes against humanity of rape, murder, as well as pillage that was going on in the facts of the case. And that was what led to his conviction at the trial level. But on appeal, this was reversed. He was acquitted because Jean-Pierre Bemba was able to show that he did take the effort to ensure that his soldiers would not perpetrate what they committed, but at the same time that he also did not know the extent of criminality that they were committing. So there were various issues around the evidence toward that, but the point being that it is possible to undermine the strength and value of insider witness testimony, and that was what happened in Jean-Pierre Bemba. Now, Kaufman was actually one of the first lawyers for Jean-Pierre Bemba. He left after some dispute over payment of fees. And so someone else took over. The reason I'm mentioning this is that also to your point earlier, John, one of the lawyers of Jean-Pierre Bemba was in fact charged with obstruction of justice, the equivalent of obstruction of justice in the case, for paying off witnesses and in a way intimidating them as well, and was in fact convicted by the ICC, even as the main defendant, Jean-Pierre Bemba himself, was acquitted. So these cases, while I think part of the context for Filipinos here is that they're looking at white people, Europeans, Westerners, litigating a global South case in a global North court in a geographic sense, right? And so there's this notion, I think, where on one hand, we see them as competent, we see them as professional, we see them as Filipinos, see them as beyond the politics of what it could have been had this been carried out in the Philippines. But I have to say that's not that veneer is really just a veneer. There are underhanded ways that are still done at the ICC level, despite the attempts by the ICC and by the judges and by the prosecutor to try to be as professional and as straightforward and as rules based as possible. So that's why I had to mention that Nick Kaufman isn't exactly the most ethical lawyer there is at the ICC.
Thank you, Attorney Ruben. Attorney Romel, would you like to add something to the ghost of Jerry Spence argument?
I would actually raise the ghost of Laurent Gbagbo, which is parallels with this case, and that's why Kaufman was talking about that there was no smoking gun, because in Gbagbo there was no smoking gun, meaning a written policy, and in Duterte there are written policies. The first one is of course the Bato memorandum circular. There were two circulars, and then there was an issuance from Malacanang suspending the implementation because of the Kian de los Santos case, right? So he was attacking that. He was raising that argument that this is just similar to Gbagbo, and he did mention the Gbagbo case, because in Gbagbo case it's also crimes against humanity, sitting head of state at that time, political violence leading to killings. So the theory was, unfortunately for that case, it was just indirect co-perpetration. There were no alternative modes of liability. And it was confirmed, but he was acquitted at trial. So the lawyers filed a no case to answer or demurred the evidence. And the trial court agreed, the trial chamber agreed. It went up, this was 2019, 2021, appeals chamber upheld the trial chamber's ruling. So there are disturbed or maybe worrying parallels here between the Gbagbo case and the Duterte case, except that we have tons of statements from Duterte, and we have the smoking gun of the Bato memorandum circular. That's why he had to go for that term neutralization. But you take that into context, because that's really what the courts look at in this case. This is not an ordinary murder case, and normally in the jurisprudence of the International Criminal Tribunals, they really look at the contextual element also. The fact that when you have a criminal party like this, you don't normally get a written memo, and that is why most of the cases are inferential, circumstantial. But in the Duterte case, it's not just inferential. There are written memos. And that, to me, is a very strong ground for, at the very least, going to trial on confirmed charges.
Attorney Romel, you raised neutralization as one of the arguments of Kaufman. I actually see two kinds of arguments from language. One is he was trying to neutralize neutralization, and also he was trying to minimize the importance of Duterte's many speeches. Can we address that? So maybe Attorney Ruben, take your pick. Do you want to talk about the argument from language about neutralization, or about this amazing claim that Duterte didn't mean any of the things that he said?
That's one. That's why there is an argument for actually conducting this trial in the Philippines, because in the Philippines, and among not just lawyers but ordinary people, especially if there were a jury in the Philippines, neutralization would be understood for what it was meant to be understood by Duterte and by the police and by the military. I used to be Assistant Secretary of National Defense in the Philippines, and the military and the police used neutralization to mean killing. There was absolutely no doubt about what it meant when they used that. But then we have this case being litigated at the ICC, where you could actually litigate the meaning of that word. And then, and unfortunately, we are dealing with judges who could be swayed one way or the other between what is official and what is colloquial, and that might be some. I think many of the arguments, the legal arguments that Kaufman was using at the pre-trial, were he was testing them. He was priming the judges for raising this at the trial. Remember that these will not be the same judges if trial were to happen, but they will be on the record. Their ruling, if they rule at all on the substantive points, will also be part of the record, and so that goes into the minds of the trial judges. Also, what Romel said, I think, is important: the no case to answer option. Kaufman has filed every motion a lawyer in this position could possibly file so far. And I am almost certain he will file a no case to answer motion at some point during the trial after prosecution presents its evidence. He has already indicated that. A couple of months ago, one of the Filipino newspapers reported that quoted Sara Duterte after visiting her father, saying that Kaufman told me that there's no case to answer. And I don't think Sara Duterte understood that conversation. She probably just understood it as Kaufman assuring her that there is no case to answer. But I think Kaufman was in fact telling her that this is what we will do at some point.
Attorney Romel, let's talk about the speeches of Duterte being diminished in importance.
Oh, I don't think they're diminished. And that's why, the Kaufman did all his best to say that they don't really mean anything. It's just, the Duterte character who likes to play with words, right? But, as the one book said, Duterte is a sovereign trickster. And in the context really of the killings, that's what the prosecutor said, that every time he talks about killing, people die. And that's why the word neutralize there is important. Well, I've also been, I think when Ruben was with the Department of Defense, I was a beat reporter. I covered the police beats, Southern Police District, Western Police District, NBI, and then the PNP headquarters and the defense beat. Every time you come across police reports, they use neutralize. It means killed. I don't know if it's still there, the Joint Operations Center report that the reporters used to write dispatches. When they talk about neutralized, it means that people have been killed. NPA or someone fighting government soldiers had been killed, right? And I did a Google search 2 days ago. The reports you still use neutralize. PNA, which is a government news agency, use the word neutralize, drawn from official reports of the military and the police, right? So that's contemporaneous practice, and perhaps they could introduce that as a form of evidence because it's still used even in current reports. And also, it's interesting about the PNP manual. I think the one that was in operation when the Bato was a 2013 version of the manual, and Kaufman cited the 2022 version. So there might have been changes already because it's 2022. But I don't know. I've downloaded that somewhere because I know that because it's a manual that was that version was the one attacked in the Supreme Court in the Daniel versus PNP case, the one that Joel Butuyan and Gilbert Andres had been litigating in the Supreme Court. So I was wondering why Kaufman was using the 2022 version rather than the one that was applied with the PNP in 2013, where you had the definition, the word neutralize with respect to the Tokhang operations nationwide.
The term sovereign trickster, of course, comes from the book by the scholar Vincent Rafael, who unfortunately has just passed away. Maybe one more question about language. I don't know if you were struck. I was certainly stupefied when in the last part of his closing statement, he started painting this picture of the visit to Duterte and how he was indifferent to the outcome and so on. He's painting this vivid portrait of a kaluoy, some pathetic person, just waiting for forces beyond his control to, decide his fate. First of all, did you did you expect that? What are your reactions, and what is that as a legal strategy, Attorney Ruben?
Well, first, the first thing to say is that it was stricken off the record. Most of it,
Okay.
because he used it as a way to segue into arguments about Duterte's health, about Duterte's capacity to go to trial, arguments that either were already ruled upon, and as the judge also said, or arguments that he could not make himself, Kaufman, because he decided, and his client decided, not to show up at the pretrial hearing. These calls to emotion, again, were obviously meant for a Filipino audience. And I think the purpose for raising them at the confirmation of charges hearing, aside from giving Kaufman an opening to then talk as if he were Duterte, one other purpose is to dilute any characterization of Duterte as a murderer, because that fits into patterns of Duterte as mayor and later on Duterte as president, that he addressed criminality by murdering alleged criminals. And so it was, I think, Kaufman trying to paint that picture of Duterte as someone who wasn't that sort of person, right? Or at the very least, cast doubt potentially later on whether Duterte was in fact that sort of person already as mayor, because some of the counts are murders when he was mayor, right? So you have to frame his state of mind at that time as well as when he became president. So segueing into that, maybe along the way, be able to paint Duterte as someone who isn't a murderer.
Attorney Ruben, can you make sense of this particular moment in the closing statement of Kaufman when he castigated counsel Gilbert Andres, representing the victims, for presenting what Andres called 10 rebuttals? And Kaufman said something like it was improper for the CLRV to present legal arguments. That went over me. Can you make sense of that?
Yeah, he called them, "You're not mini prosecutors," which not only I think was disrespectful of fellow lawyers. A lot of effort and campaigning and pressure went into ensuring victim participation at the ICC, and I was involved in part of that. A lot of effort has gone into making sure that not only do victims participate, but they participate through lawyers. And there have been attempts, in fact, to dilute that. One of those attempts has succeeded, in fact. That's why you now have common legal representatives, only one or two lawyers representing all victims, regardless. In other words, they don't get to choose who their lawyers are. It's the ICC effectively that chooses. But they're there and they're able to participate. They're not prosecutors. They are legal representatives of the victims. And for Kaufman to then say, you're not allowed to do that, you're not mini prosecutors, not only distorts the meaning of victim participation, it was also racist. And I have to say this, that racism isn't, just some accidental thing. I think it comes from his background as a lawyer of the IDF, of the Israel Defense Forces. It comes from this background where you have been empowered to dehumanize people so much and use the law to dehumanize people that it's so casually done, it's so casually stated at that hearing.
Attorney Romel, another instance that also stumped me. Can you also make sense of this? Kaufman ridiculed the, I think it was incident one, where a witness supposedly heard Duterte speak on the phone. And he said, we cannot verify that it was actually him. What was he trying to do there? Did it make an impact on the case?
Well, he actually said that that was hearsay, and if you're saying that it is your proof that that Duterte ordered the killings, then legally that will not hold water. So that was really the central argument there. It's hearsay. You can't really prove that the person at the other end of the line is Duterte, and therefore there's no one you can pin to as the one who gave the order to kill.
Did he oversell it though? If I may be mistaken, but I think that incident refers to the mayoral period. Is that correct?
Yeah.
Yeah. So in his counter argument, he says, "Can you imagine? You identify the president of the Philippines just through his voice, when in fact we were not talking about the president then. He was just CM or Superman." Was he overselling that?
Yeah. Well, I think it goes into the whole theory of indirect co-perpetration also, not just ordering and inducing, because the way the theory is presented, there is a common plan that was first hatched in Davao, and then it became nationwide, and that goes into the idea of a common plan. So if you actually sever the Davao aspect, which is foundation of the theory, he probably was thinking that then the whole idea of plan will collapse, right? Because remember, the national there, even the Tokhang policy, is said to be a direct copy of the policy that Duterte crafted when he was mayor of Davao, and which he was able to implement because his inner circle in Davao became PNP chief and the chief. So I think that is what he was trying to do there,
right.
to attack the main narrative.
I think we just lost.
Let me add to that,
yes,
John,
please.
while we're waiting for Romel. Kaufman has handled ICC cases involving war, but not a drug war. And that makes a very important difference because the cases he has handled involve conflict in the Democratic Republic of Congo or involving, war criminals or involving actual violent armed conflict between two armed groups. But not a drug war involving a mayor, involving a president. Even the Bagbo case, which is cited, involved an actual war. It did involve a president, but it involved war between two factions in the Ivory Coast. And this was frontal war. This was, entrenched face-to-face war. This wasn't a drug war where you had death squads, where you had a mayor, all powerful, and then a president who then became even more powerful. And therefore, to try to characterize insider witness testimony and claims about how people heard Duterte as simply hearsay or at least not, not credible. I think he's coming from a context where the fog of war and the mess of armed conflict makes that possible, but not in a setting where you're in a city where things function, at least on the surface, or the presidency, where you have the entire state behind you, and not, in fact, engaged in a war with an armed group that exists to fight you, rather civilians targeted in crimes against humanity. So I don't think that Kaufman realizes that he is litigating a case, or maybe he has realized it, but not fully, that he is litigating a case that is very, very different from cases that have been litigated at the ICC on crimes against humanity charges.
We're running long, so one last question for the both of you. I'll start with Attorney Romel, and then we'll end with Attorney Ruben. Just very simple. What did Kaufman need to do at the confirmation of charges hearing, and did he do it? Attorney Romel? Okay, it seems that our connection to Quezon City is less robust than our connection to New York. Let's start with Attorney Ruben.
No, I think in some parts he did do what he should have been doing at a pre-trial confirmation of charges hearing, which was to erode the possibility of the judges seeing substantial grounds to go ahead and do a trial. I think he did manage to point to the obvious, that insider testimony is unreliable, that speeches can mean two different things or even more different things than just an order. I think he did manage to do what he obviously should be doing. The problem, though, is that the judges also are aware, obviously, that this is just a confirmation of charges hearing, and that these insider witnesses, when presented, would be able to explain inconsistency, would be able to testify credibly. So this is not beyond reasonable doubt standards. So that also is both a problem and a possibility for the defense of Rodrigo Duterte.
I'll change my question for Attorney Romel. Are we headed to trial?
Definitely. We have three modes of liability here. And I will not be surprised even if there's going to be a mix of findings in this case on any of the three counts, given the tons of evidence and given also the evidentiary threshold, which is not proof beyond reasonable doubt at this stage.
So even if he is found to have the lowest form of liability, aiding and abetting, it will go to trial on any one of the three counts. All right.
Yes.
A substantial and trenchant critique, Attorney Ruben Carranza and Attorney Romel Bagares. This has been enlightening. Thank you very much. And that's it for us today. The challenge for engaged citizens in our country remains the same: to fully inhabit the democratic space and defend the democratic project. Please download the Rappler Communities app and join the chat room of your choice. And if you haven't yet, subscribe to Rappler Plus. Thank you. This is John Nery. See you in the public square.